The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning and welcome to the docket of the Kansas Supreme Court. I will ask Mr. Doug Shima, the clerk of the appellate court, to please call the morning docket.
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Wednesday, May 26, 2021 consists of one case. Appeal number 19764, State of Kansas versus Tommy L. Jones. Sedgwick County briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Counsel, would you please enter your appearances?
Tommy Jones appears through counsel Michelle Davis. Ready for argument?
May it please the court, Assistant District Attorney Matt Maloney for the state, present and ready for argument.
Thank you, counsel. Ms. Davis, you may begin.
Thank you, Your Honor. The state's evidence in this case would show that Mr. Jones, who is 27 years of age, played an online game and his character interacted with another character. Mr. Jones said that at first he thought it was a guy behind the character, and then he found out the account showed the person was 18. In the month that the events in this case took place in November, it was a 16-year-old named Abby who lived in Pennsylvania who was about 2 months shy of 17. Abby had a fight with her mom and she went to get on a bus to come to Kansas, and her mom contacted law enforcement and she was intercepted. And the state of Kansas, it was fairly easy for them to investigate Mr. Jones because he was on parole. And so they took his phone and did forensic searches, et cetera. So they state, the state's evidence here is that several days before the bus incident, Abby had, Mr. Jones had asked Abby for photos, but it was during a conversation that was sexual in nature. And Abby sent, the state charged 2 sexually explicit photos that were found on Mr. Jones's phone. In Kansas, sexually explicit covers genitals, breasts, nudity. And so the state charged Mr. Jones with 4 crimes, 2 in the alternative, for possessing the photos, and then under the statute, a different subsection of promoting the photos. At trial, the judge actually instructed the jury on the possessing of photos, but then on a different subsection. Instead of promoting, which was charged, the judge instructed the jury on persuading a person under the age of 18 to engage in the conduct. The jury convicted Mr. Jones of all 4 crimes. The judge entered 4 convictions. The judge sentenced Mr. Jones for 2 of the convictions, which were the promoting offenses. The Court of Appeals agreed with our argument that the court could only enter 2 convictions because they were charged in the alternative. The court agreed with our argument. The district court had sentenced Mr. Jones because he had a prior case. He had 2 prior convictions within the same case. But because this was his 3rd offense, the district court had sentenced him to life without parole as an aggravated habitual offender. The Court of Appeals found that under the rule of lenity, Mr. Jones should have been sentenced as a persistent sex offender, which is double the grid. These were charged as level 5 crimes. That's what they're categorized as in Kansas. So as a persistent, it's double the grid. The state petitioned on 2 issues, the loss of its 2 convictions and the sentence issue. We petitioned on 4 issues, which are challenging the remaining 2 convictions. And then also our claim that because these were charged as level 5 offenses, Mr. Jones could only be sentenced as level 5. So in other words, the 3rd choice, the lowest choice, straight up is a level 5 sentence. So that's what's before this court today. And I think it kind of helps to start a little bit. I kind of want to cover a couple of issues. The fact that Mr. Jones was convicted of crimes that weren't charged. And then also the statute's unconstitutionally facially overbroad. So just to clarify, under the statute, there were 3 subsections in play here. You've got the persuading, that's the actus reus, then you've got the possession, and then the third is the promoting, which is kind of like distributing, receiving. The crime doesn't specify a mental state, so the culpable mental state. So in this case, the judge instructed the jury on intentionally. So you intentionally possessed, you intentionally persuaded, you intentionally promoted. And then the judge instructed that the state does not have to prove that Mr. Jones knew that the person depicted was under the age of 18. The persuaded subsection, I'm going to focus. The state charged persuaded. The state charged promoted, which is the third option, the distributing. The judge actually instructed on the persuaded. Just as an initial point, you can't do that under Kansas law. There's a statute that specifically says the state cannot amend the complaint during the trial to charge a different crime. You can't convict Mr. Jones of promoting when that wasn't instructed to the jury. And you can't convict him of persuading because that wasn't charged. So in my mind, the only valid conviction here is really the possessing the photo. Those are the alternative counts. That's the only valid that he can be convicted of. And so I'm going to focus on that. It's our contention that Court of Appeals found that the promoting wasn't that significantly different from the persuading. It's our contention that it is, because the promoting is the only one that requires, the statute reads promoting, which is the procuring, distributing, producing, the sexually explicit photo, knowing its content and character. And that was Mr. Jones's defense in this case, is that I didn't know she was going to send me these photos. That's the only one that you have to show that the defendant knew the content and character. And so in our mind, those are different. And again, that's what the state charged, but the jury was never required to find that because it wasn't.
I have a question. In reading the Court of Appeals decision, it looks like they analyzed this as instruction error. But then in your petition for review, one of the things that you say is that that was erroneous. The panel, in its opinion, applied the analysis for a statutory jury instruction error. It did not address appellant's claim of a fundamental right violation. And in looking at the case that you cited, it looks like what you're saying implicitly is that it should be analyzed under sufficiency of the evidence. Is that what you're saying? I just wonder what standard of review, how would you like us to analyze this error?
That's correct. And I think I'm relying on the Trotloff line of cases that talk about prejudice of substantial rights of the parties. Because in those cases, they don't analyze this as a jury instruction issue, that this is more of a fundamental right to the jury determination of guilt as to every element charged and basically due process, fair trial. And then I also rely on the Kansas statute that says as part of that due process that you can't amend the complaint. You can't amend the complaint through the jury instruction to charge a different crime. So basically, you just can't do this.
Right. So I'm looking at the State v. Dixon case, and that was the sufficiency of the evidence. That's what you cited in your petition, where they analyzed it under, they did reverse because they said there was insufficient evidence to support the jury instruction.
Yeah, Dixon was a little bit different because the evidence established another offense, but the state didn't charge that.
Well, isn't that what happened here?
Well, the state in Dixon, the state charged a violation of one subsection, but the evidence showed a different subsection. But I think
is that not what you're arguing here? Maybe I'm confused.
Yeah, and I had trouble with this issue too, because this is a little bit different. I think that I can't remember back to Dixon with the instruction issue. I think I think in Dixon, they charged it and they instructed it, but the evidence showed another offense. So I can't remember. I have to go back at Dixon and look at the jury instructions. But in a way, I'm saying that, but it goes deeper than that. It goes to the fact that they amended the complaint effectively. When you charge a different instruction, you constructively amend the complaint. You basically change the charge. And so I think I had trouble in my brief sort of pointing to exactly what the problem is. And I think what I came to is you just can't do it. It's just not allowed under Kansas law. And I'm sorry, I have to go back to Dixon. I'm not really sure on the instructions on that.
Just a quick clarifying question. Is it your position? Well, I'll just state it simply. Do you think this was just a mistake? Or are you arguing that this was intentional in some way, either on behalf of the state or the court?
I didn't see anything in the record where this was discussed. So it appears to be a mistake to me.
And returning to how we are to analyze this, you mentioned that you're relying on Trotloff line of cases. And Trotloff does discuss this in the context of a jury instruction that's broader than the charging document and does so applying a instruction standard of review rubric. So is that what we would do, is look at it through the lens of it being broader than the charging document, but do apply the clearly erroneous standard?
Well, no, because the difference in Trotloff is they broadened the complaint, but they still was under the same subsection. So in other words, I think they were still talking about promoting. They just changed the way you promote. They charged one type of promoting, and then in the jury instruction, they instructed the jury on another type of promoting. So they didn't charge a different crime. They just broadened the definition of the crime that they charged. In this case, they charged a completely different crime. And it's our contention when you have different subsections, you can't just say they're the same crime or they're close enough. They're not. There's a reason that the legislature has different subsections. So I think that's why I struggled in my brief to sort of give you a standard harmless analysis, because I don't think there is. I think you just can't amend the crime. It would be like charging ag battery and instructing on kidnapping and then saying there's evidence to support the kidnapping. It doesn't matter. So I think that's where I'm at with this. And then I have, yes.
Wouldn't you say though that subsection 1 is the defendant's actions in attempting, and then subsection 4 addresses the accomplishment of actually attempting and receiving the materials such as the picture?
There's a difference though. It's not a straight up attempt, because the 4th option says knowing the content and character. It's the only subsection that has that in there. So it implies that you're actually looking at the photo and then you're doing something with it, or you know the content in doing the conduct. The first one doesn't require that. Just says you're persuading the conduct with the intent to obtain the photograph. But the only intent on that is to obtain the photograph. There's no knowing the content and character. And that's much more, that's a pretty significant element, that you know the content and character. He hadn't actually looked at the photos and then decided to distribute them or do something with them, or he didn't know what the photos were going to be. That's the difference. So subsection 3 has an additional element that subsection 1 does not. I'm sorry, did I say subsection 3? Subsection 4 has a different element that subsection 1 does not.
And your point there does not go so much to the age of Abby, but to the nature of the photos that were going to be sent. Is that true? When you say character and content, you're talking not necessarily about how old she was there, but just what kind of picture was she going to send?
That's right. That's right. Exactly. So you can be asking for a photo and have a sexual content, but that doesn't mean you anticipate you're going to get photos showing genitals. Absolutely.
But is that subsumed within the definition of promoting in the statute?
The promoting,
That-
I'm sorry, just.
Oh yeah, go ahead. That in particular, that the definition includes an intent element that you're procuring or transmitting or engaging in some sort of actus reus with intent to arouse or gratify sexual desire or appeal to the prurient interest of the offender.
That's in the second subsection. That's the possession. The possession has the intent for sexual interest, right? I'm possessing a photo of sexually explicit conduct with satisfy some sort of sexual intent. The third just simply says I'm promoting, which is the producing, procuring, knowing its content and character. It doesn't have that additional intent.
Right, but I'm looking at D2, the definition of promoting.
Right, but that's the intentionally actus reus. It's different from then the second, knowing the specific sort of. All of them have a second specific intent or knowledge requirement. And those are all different depending on the subsection.
Knowledge versus the act itself.
Right, in addition to the mental state for the act. So we have the mental state for the act, which is the persuading, possessing, promoting. The promoting has a knowledge additional requirement that's beyond what for the other two. Now I'm out of time. I didn't get to my other issue, but I'll save that time for a rebuttal. Perhaps I can address any questions this court has.
Thank you, counsel. Mr. Maloney?
Thank you, Your Honor. May it please the court, Assistant District Attorney Matt Maloney for the state. Certainly, I'll be happy to address any questions that this court has on any of the issues, but my plan, with the court's permission, would be to focus on the two issues in the state's petition for review. And I think I'd like to start with what was issue 3 in the original briefing, which is the question about what to do with the fact that this defendant was convicted of alternative counts. That's certainly been an issue that has been talked about recently. I believe just in December, this court heard an oral argument in State versus Vargas that involved the same question. Our position on this issue is that this court needs to give guidance to district courts and prosecutors and defense counsel, for that matter, with respect to how to handle this type of situation. It's certainly not an uncommon scenario for the charges to be charged in the alternative. And if the jury does convict of the alternative counts, there needs to be some clarity with respect to how to handle that. I think I set forth in the original brief and the petition our position, which is that in this situation, there is no real concern with double jeopardy because the defendant has not had sentences imposed on the alternative counts. And I think that there is no need to dismiss or reverse or vacate the alternative convictions in this scenario because of that fact. The defendant has relied in his briefing on Garza, and that is the case that the Court of Appeals panel relied upon in determining that they were duty bound to follow that precedent. Our position is that Garza should be revisited, that Garza simply relied on another case, Dixon, which dealt with an entirely separate issue. Dixon involved a question with respect to a jury instruction. And it was in the course of deciding that issue that the court declared in what I would consider dicta, a brief statement about how when a defendant is charged in the alternative, he can only be convicted of one offense. And so Garza and cases that have followed have simply relied on that without any independent analysis of this issue. And so our position is that this court should consider this issue in depth and is not necessarily, well, obviously you're never bound to follow your own precedent, but we would ask this court to revisit Garza and give guidance on this issue. And I set forth in my briefing multiple alternatives on how this can play out. In this case, the court accepted the verdict and pronounced what the sentence would have been on counts 2 and 4, but didn't actually impose that sentence. And I think that's one viable option. There are other times where the court can simply accept the verdict or might not even pronounce what the sentence would have been. I think that that's also acceptable. But I don't think that there's any need to vacate the convictions, the alternative convictions. And I cite State versus Penn as an example of what the potential harm is in a scenario like this. If there's nothing infirm with the alternative counts that the jury has found guilt on beyond a reasonable doubt, there's simply no need to vacate those convictions, so that then down the road, if a defendant is able to obtain relief on the convictions for which he was sentenced, if those are reversed and the alternative counts have been dismissed, then the defendant escapes any liability, even though there was nothing wrong with the alternative counts. I cited to an Alaska appellate opinion in Heard, and I think that case would better represent what the state would have this court hold is the appropriate situation. So to summarize, because there's no double jeopardy concerns where the defendant has not actually been sentenced on the alternative counts, we believe it's unnecessary and harmful to reverse an otherwise valid conviction that the defendant has not suffered any consequences from. So we would simply ask this court to revisit Garza and do more in-depth analysis rather than simply relying on a case that dealt with an entirely separate issue. The other issue that the state petitioned for review on is the question about the sentence and whether he should have been sentenced on under the aggravated habitual criminal or aggravated habitual sex offender or as a persistent sex offender. And with respect to this issue, our position is that where the Court of Appeals went astray is in analyzing the issue, they focused and they've determined that they were duty bound by this court's opinion in Turner and then ultimately in Green. Our position is that those cases are not binding because they involved a different provision of the persistent sex offender statute. We would ask this court that when you're analyzing this issue to focus on the specific subsections of the statutes that are relevant. So with respect to the persistent sex offender statute, you should be looking solely at KSA 216804J2 subsection A, rather than the subsection B, rape subsection, which does not apply to this defendant. Quite simply, he was not convicted in this case of rape. And so the Turner opinion, when you read, clearly it was focused on the rape subsection because that's what Turner was convicted of. And so in going through the statute in that case, the court placed great emphasis on the fact that especially when you consider that rape subsection, there is an argument to be made that the persistent sex offender statute is the more specific. And because they had found that in another subsection, there is an argument to be made that the habitual statute was the more specific, they essentially said it's not possible really to determine, and therefore we're going to default to the rule of lenity. Well, here we don't have the same issue. That subsection B, rape subsection, is out the window. It simply does not apply. So when you compare the only relevant subsection of the persistent sex offender statute with the subsection of the aggravated habitual statute, then the only difference between those two statutes is the requisite number of prior convictions of a sexually violent offense. Our position is that when a person like the defendant has been convicted of more than one, when they have at least two prior convictions for a sexually violent offense, that does mean that in that context, the aggravated habitual sex offender statute is the more specific provision, and that therefore it should control. Again, that's the only difference between those two subsections is the number of requisite priors that a offender has to have. And so again, I think when you're looking at comparing statutes, the key is to compare the relevant subsections of those statutes. defendants like Turner, I think that the court's opinion was reasonable, that in that particular context, there is an argument to be made that it's unclear which statute is more specific, and therefore the rule of lenity discussion made sense in that case. But here, the panel seemed, while they acknowledged that Turner involved a different issue or a different subsection, they nevertheless seemed to determine that they were more or less bound by that opinion, or that its rationale still applied in this context. And our position was that was in fact a mistake, and therefore this court should evaluate the issue solely under the relevant subsection of the persistent sex offender statute, and hold that the district court in this case properly sentenced this defendant, who was not convicted of rape in this case and had 2 or more prior convictions of a sexually violent offense, as an a bit aggravated habitual sex offender. I know that the one issue that defense counsel focused on in her argument today was issue 4, with respect to the error in the jury instruction. We acknowledged in our briefing that the instruction was erroneous in that it did set forth a different subsection of the statute than what he was charged with. Our brief was consistent with the Court of Appeals analysis, which is that this really is a jury instruction issue. There's no question that the complaint itself was properly drawn. There's not a deficiency in the complaint. The problem came in only because the jury instruction was erroneous and cited and included the language of a different subsection. Because of that, we do agree with the Court of Appeals that this should be analyzed under the jury instruction standard or review, which in this case is a clearly erroneous standard because there was no objection. Our position is that this error was harmless beyond any doubt, that there was absolutely overwhelming evidence that he was guilty of the crime that had been charged in the complaint. Basically, that I think the Court of Appeals did a nice job of going through all of the relevant definitions. And when you go through those definitions, what you find is that in order to convict him of the charged offense, the state needed to prove that the defendant procured, which means obtained, a performance, which includes photographs, that included sexually violent conduct, and that includes nudity by a child.
Maloney, may I ask a question?
Sure.
Yes. What would you say to counsel's argument that it would be like charging rape and then having a jury instruction on kidnapping? I mean, these are 2 alternative counts with different elements, right?
They're different subsections within the same statute. So I don't quite agree that it would be the same as charging one crime and instructing and convicting on a completely separate crime. These are both subsections within the same statute, the sexual exploitation statute. So it's simply a difference of subsections and the specific manner of proof that's at issue rather than an entirely separate crime. And so I think that does distinguish it from the example that counsel gave.
Okay, so it is the manner of proof, right? So wouldn't that be a sufficiency of the evidence issue?
Well, I think, again, our position would be that this is an instructional issue because that's where the problem comes in, is the fact that the instruction simply used the wrong subsection, the wrong language. And I agree with counsel. I don't think there's any indication in the record that this was anything other than just an oversight on everybody's part. Again, we would prefer, we believe that this is an instructional issue. We would note that I think regardless, even if you were to look at this as a sufficiency of the evidence problem, ultimately, I think the result is the same because as the panel held and as we argued, there was overwhelming evidence that was presented to prove the charged offense. Again, we proved that he obtained a photograph that included a child under the 18 under 18 engaged in sexually explicit conduct, that being nudity. And while counsel has focused a lot on the knowledge element and said that, well, this is why it's problematic because his defense was based on knowledge. When you look at the evidence in this case, what you see is that the defendant and the victim engaged in numerous sexually charged conversations. And it was in the midst of one of those conversations in which the defendant expressly asked her to send a photograph. And I would also note that on the same date of that chat, he specifically referenced in one of the communications the fact that he knew that the victim was 16 years old. So here we have a situation where he not only knew the victim.
Let me interrupt you very quickly. It's interesting what you said, that his defense was, I didn't know the character and content of the performance, which makes sense that would be his defense because that's in count 1 of the second amended information. So now he's been put on notice that this is what he's charged with. His whole defense, I mean, beyond, the not knowing the age situation, which I think he eventually admitted he knew the age, but that he didn't know the character and content of the performance. And then when the jury instructions come out, it's not even there.
Right.
And his whole defense is not even a defense anymore.
Right.
You think there's prejudice there?
Well, I think there could be if there were not evidence that he did in fact know the content.
How did he know the content?
I think.
How did he know that they were? I mean, he asked for pictures, and it was during the course of some sexual discussion. But how did he know he was going to get those photos? What showed that he knew the character and content of what he was going to receive?
I think like any element, that would be a question that can be shown by circumstantial evidence. And here, the evidence being the fact that this request for the photographs came right in the middle of this very sexually explicit conversation. And so while he's certainly free to argue that, well, that doesn't necessarily mean that I was requesting nude photographs or any type of sexual photograph, I think that even had that element been included in the instruction, the jury certainly had overwhelming circumstantial evidence that was clearly what he was intending. He wasn't simply asking for a school photograph or something benign. He clearly asked for that with a specific purpose and knowledge. And so while yes, his defense was based in part on saying that he did not know the content, I think there clearly was sufficient evidence otherwise, and that would support the finding of harmless error in this situation.
Is this a situation more akin to our case law where an element is omitted from an instruction? And in that case, it's not necessarily a sufficiency of the evidence, is it? I mean, we don't just look for the bottom. Oh yeah, there was some scintilla of evidence. Don't we require a higher standard than that? And I guess the follow-up question to that, which I'll ask before you even answer the first one, is are there examples in the case law where we have filled in that hole when there has been a dispute about that point in the evidence?
Off the top of my head, I don't recall specifically that area of the case law as well as I would like to. I think because this had been analyzed as an instructional issue by the panel, and that was what the state also believed was appropriate. I certainly have worked on some cases in the past that involve a missing element. I don't specifically recall the language that this court has used on appeal in determining whether such an error is harmless and whether the court does require a greater degree of proof than it normally would in a sufficiency of the evidence challenge. But as to the second part of the question, our position would be that even if that in fact is what this court has required, we still believe that the defendant's request in this case would meet even a higher degree of proof. This is essentially the classic example of somebody during an online sexual chat requesting a photograph with a clear intent in mind. And I think the defendant's own knowledge is just further shown. When you look at all those chats as a whole, you see that there's one instance where he even expressly notes the fact that he knows he could get in significant trouble because of his conduct. And yet he talks about the victim being worth the risk. He asks her at some point to delete all communications or all evidence of him from her computer. So for the defendant to suggest that there was not overwhelming evidence, that he was fully aware of the content of the photographs that he was requesting, I think, again, is something that he was free to argue to the jury. But I simply don't see any possibility, even under a heightened standard, that this would have affected or led to a different outcome. And I know I'm well past my time, so I'll be happy to answer any remaining questions at this point.
If it's all right with the chief, I have a quick question.
Yes, go ahead.
I'm not sure whether either the state or the defense cited to our State v. Brown decision from last year, in which, and it's not directly on point, but I just want to ask both counsel and in rebuttal time to Ms. Davis, whether or not you think that case has any relevance here. And that was the case in which we held, we weren't talking about jury instructions, we were talking about a jury verdict form, and we held that if there's a mistaken description of the crime of conviction in the verdict form, that we treat that as, it can be treated as surplusage and can be disregarded if the jury's verdict is responsive to the charge. And I just wanted to ask whether or not you had considered that case, and does that have any applicability as we try to figure out what's our standard of review?
I had not specifically considered it because I don't believe it was cited by defense at any point. But I do think that there would be some, again, off the top of my head, I do think that there is, it sounds like there would be some similarities in that standpoint, from that standpoint, in that while here the language in the instruction was not consistent with the charge, and therefore there would be, I guess it could be considered surplusage. And I would argue that yes, it could be, and it should be disregarded in this context, again, because there was so clearly evidence presented to support the charge defense. And I think that because all indications are that this was simply an oversight at the instruction phase, clearly both sides were proceeding at trial under the charge that was listed in the complaint. And so that was what the state's evidence was geared toward. That was what the defense, the theory of defense, was geared toward. And so both sides were proceeding under the correct theory while they were arguing and presenting this case to the jury. And so because of that, I think that there definitely is an argument to be made that rationale from the Brown case would apply here, and that we could simply disregard the error as being something that didn't have any impact because it was not, it truly didn't affect either party's theory while the case was before the jury. If there are no further questions, we would simply ask this court to reverse on the two issues that the state has petitioned on, and we would otherwise ask the court to affirm the rulings of both the district court and the Court of Appeals on the remaining issues.
Thank you, counsel.
Thank
Ms. Davis?
Just to quickly respond, my understanding of the Dixon case is they charged a subsection, instructed on the subsection, but they charged the wrong subsection. In other words, they proved a different subsection. That's how, but the point, the soul of Dixon still applies. You can't convict somebody of something that you don't charge. So Dixon is definitely applicable. And this is not surplusage or an element. This is the whole key to the subsection. You promote knowing its content and character. You can't separate that from that is the crime. So this isn't something that, and again, I'll go back to the Kansas statute. Kansas statute doesn't allow it. It's a procedural due process violation, 223201. Specifically says you can't amend the complaint during the trial to charge a different crime. You just can't do it. So if I have to rely on that statute to say you can't do it under Kansas law, then that warrants reversal of the convictions. I do want to make it clear, though, that we believe that all of the convictions should be reversed in this case. And I want to get to the statute substantially overbroad. I think that's pretty well briefed. So I'm happy to answer any questions from the court. But basically, with a statute that's under 18, it's constitutionally overbroad because it criminalizes what could be otherwise innocent conduct, because adults have a First Amendment speech right to possess sexually explicit material that's not obscene. And so if you don't have a knowledge requirement, you're not only criminalizing conduct that could be innocently done, but you are infringing upon that right, because basically you should be in fear of possessing any sort of sexually explicit material involving a young person in this state, because no knowledge is required. It's a strict liability crime. That's what makes
Counsel.
That's the issue that the Court of Appeals declined to take up because it hadn't been preserved below. Is that right?
That is correct. That is correct.
And so how did the Court of Appeals abuse its discretion in deciding whether to take up that issue?
Because the Court of Appeals said that I hadn't briefed why this violated a fundamental right. And I did brief why it violated a fundamental right. There's several pages discussing the right of free speech, as well as case law explaining how this violates a fundamental right. So I did adequately brief the issue for the court to consider. I did provide an exception. I'd be happy. Yes.
Counsel, you agree, though, that child pornography is not protected by the First Amendment?
That is correct. That is correct. Child pornography is not. That's the exception. So the fact that that's true. It isn't protected, but you have to, in order for it to be done with a guilty mind, you have to know that it's child pornography. There's no guilty mind here if you don't know it's child pornography. If you believe you're receiving a sexually explicit photo from a 19-year-old who happens to be 17, your innocent conduct has made you guilty of a crime.
How is that constitutionally protected? That's where I'm trying to connect the dots on your argument. I don't if you possess it, like, how is that act constitutionally protected? So, regardless of what the mens rea is.
We are making that the statute is facially overbroad, that in trying to criminalize child pornography, you are sweeping in a whole range of conduct that is constitutionally protected.
So can you articulate for me a hypothetical in which this statute would criminalize constitutionally protected acts?
Where you are talking to another person, you're flirting with another person on the phone, you believe that person to be 19 years old, you say, send me a photo. They send a photo, somebody looks at your phone, and the person depicted is actually 17.
I guess that's my question. Why is that constitutionally protected?
Because you have a right to ask a 19-year-old. That is sexual expression that is protected by the First Amendment.
But that's not what factually happens in your hypothetical.
In my hypothetical, it is, because I believe I'm talking to a 19-year-old and I believe I'm engaging in protected speech.
So your argument is that the First Amendment really bars the creation of a crime that doesn't have a mens rea element, doesn't have a...
That's right. There's no guilty mind requirement here. There's no knowledge that's exactly. And plus the infringement.
Ms. Davis, take it the same scenario, but a different age. Let's say that you think you're talking to a 19-year-old, but the sexually explicit or photo content that you're requesting is that the person's 9 years old. Any difference?
I'm sorry, Justice, could you give me that?
Yeah,
hypothetical?
the example you gave was that the person who elicits or solicits for the photograph is you think is 19 but is 17. Well, what if that person you think is 19 is 10 years old, and that 10-year-old sends a photograph? Same outcome?
Yes, you're guilty. I mean, you're guilty of a crime in Kansas, yes, because you possessed, it's a strict liability crime. You possessed a sexually explicit photo of someone under the age of 18, yes. And so I think that the possible infringement upon free speech is even more applicable or egregious because the statute changed from under 16 to under 18. And so the fear is even more present because the 17 or 16-year-old could look like an adult or could behave like an adult or act like an adult or claim to be an adult. So this is, I think, is the first case challenging where you have somebody who is close to the age of adulthood. And so I think that the fears are even more applicable than in the prior cases from years ago. That concludes my time. I'm happy to answer any questions, or I'd like to sum up if I can, Chief Justice.
Yes, I just want to make sure Justice Stegall didn't have a question. If he was...
I guess I'll ask really quickly. I'm still struggling with the notion that the First Amendment protects against this mens rea element, but it sounded like at the very end, what you're really, well, I don't want to put words in your mouth, but what it sounds like is that you're making a chilling argument that the lack of a mens rea requirement actually, so it doesn't necessarily criminalize protected behavior, but what it does is it chills. There is a chilling doctrine within First Amendment law. And that's more, I don't know, just could you respond to that? That sounds like the argument you're making, that it's not actually criminalizing constitutionally protected behavior, but it does create a chilling effect on constitutionally protected behavior.
I think if you look at Excitement Video, which is the case I rely on in my brief, they talk about this, that without a mens rea requirement, it criminalizes conduct that is otherwise innocent, and it also creates a chilling effect on First Amendment speech. So in that case, they covered both of what you're talking about. I don't think I'm trying to say that that there's a constitutional right to possess child pornography. I'm not saying that. I'm just saying that without the mens rea element, it criminalizes conduct that otherwise is innocently done. And in summation, we would just ask that you reverse the convictions and find that the state prosecuted Mr. Jones pursuant to a statute that's facially constitutionally overbroad. Thank you.
Thank you to both counsel for your arguments in this matter. We will take it under advisement. Court is in recess until